Now, this is the most significant Second Amendment ruling in more than a decade.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
Pretty based move here by the state of Missouri, saying, no, we are not going to fund federal violations of the Second Amendment.
8 Supreme Court justices just sided with the federal government against a state that tried to protect gun owners from federal enforcement, and the decision sent shockwaves through Second Amendment advocacy groups nationwide. But here's what makes this ruling genuinely fascinating. It wasn't actually a rejection of gun rights at all, and the case might have unintentionally provided a roadmap for how states can successfully resist federal gun control in the future. One justice stood completely alone in dissent, and what he wrote in that opinion signals a much larger constitutional battle brewing over federalism and state sovereignty. Once you understand what Missouri actually tried to do, why it failed so spectacularly, and what Justice Thomas revealed about the correct path forward, you'll realize this isn't the defeat for gun rights that headlines are suggesting. This might actually be the beginning of a much smarter, more constitutionally sound strategy. The case started quietly, buried under technical legal filings and procedural arguments that most people never pay attention to. But when the Supreme Court decided to take the case and actually rule on it, everything changed dramatically. In a stunning 8-1 decision that surprised legal observers across the political spectrum, the justices completely dismantled a key gun rights law that had been passed in Missouri. And in doing so, they've drawn a sharp new constitutional line in the sand for every state in America that's considering similar legislation. This ruling doesn't just strike down one state law and move on. It fundamentally opens the door to a nationwide legal fight over exactly how far states can go to protect Second Amendment rights against what they perceive as federal gun control overreach. We need to break down what the court actually said in their opinion, what Justice Clarence Thomas revealed in his powerful solo dissent, and what all of this means for gun owners, for state sovereignty, and for constitutional freedoms going forward. When Missouri passed its Second Amendment Preservation Act, often referred to as SAPA, the legislative goal was absolutely clear: protect gun owners residing in Missouri from what the state legislature viewed as federal overreach on firearms regulations. The state put forward one of the strongest and most aggressive legal challenges ever seen against federal gun enforcement authority. It worked successfully for a brief moment, creating genuine uncertainty about federal enforcement capabilities within Missouri's borders. Then the federal government and the court system turned their full attention to systematically dismantling it. This case rapidly became the centerpiece of a national constitutional showdown between state and federal authority. Missouri attempted to functionally block federal gun law enforcement inside its geographic borders through state legislation. The law imposed severe financial penalties on any state or local law enforcement agencies that chose to cooperate with federal gun enforcement efforts. Missouri argued, based on established constitutional doctrine, that states cannot be legally forced to enforce federal laws, a principle known as the anti-commandeering doctrine. The federal government immediately challenged the statute as fundamentally unconstitutional and violating basic principles of federal supremacy. The case was always destined to reach the Supreme Court based on the magnitude of the constitutional questions involved. But absolutely no one expected the ruling to be this decisive in favor of federal authority, or the critical constitutional lesson it would deliver for states attempting to defend their residents' rights through legislation. The Supreme Court sent an unmistakably clear message in their 8-1 ruling. Federal authority cannot be systematically undermined by state legislation that attempts to declare federal laws invalid within state borders. Even traditionally conservative justices aligned against Missouri's specific approach. But this is the critical distinction that many commentators are missing. This was absolutely not a rejection of gun rights themselves. It was a rejection of the specific legal mechanism and approach that Missouri used in crafting this particular law. While 8 justices rejected Missouri's legal strategy as unconstitutionally structured, the court's opinion carefully emphasized principles of federal supremacy and constitutional structure, rather than attacking Second Amendment protections. Justice Clarence Thomas was the sole voice on the court willing to grant Missouri at least temporary relief while the case proceeded. The decision explicitly did not weaken the Second Amendment protections that were established under the landmark Bruen decision from 2022. This ruling did not close the door on states defending gun rights through legislation. It only definitively closed one particular path that states had attempted to use. Missouri's legislative approach included imposing steep financial penalties against law enforcement agencies and officers. The state specifically intended to deter any cooperation with federal gun enforcement operations by making that cooperation financially devastating. But the penalty system backfired catastrophically as lawsuits surged and agencies faced severe financial exposure. Officials across Missouri were forced to choose between complying with federal requests or facing potential financial collapse of their departments. The law imposed $50,000 penalties for cooperating with federal gun enforcement in specific circumstances. Nearly 50 separate lawsuits were filed within just months of the law's activation. Local law enforcement agencies faced risks of hundreds of thousands of dollars in cumulative penalties. Department budgets became strained simply from the legal costs of defending against penalty claims. The legislative intention was clearly to build a protective shield around gun owners. Instead, the penalty structure created internal governmental fragmentation that courts ultimately viewed as destabilizing the relationship between state and federal authority rather than legitimately protecting constitutional rights. Missouri borrowed strategic concepts that had been used by immigration sanctuary jurisdictions in liberal states. The underlying idea seemed simple and logical. If cities can legally refuse to assist federal immigration enforcement without penalty, then states should be able to refuse federal gun enforcement using the same constitutional principles. But a critical legal difference separated these two approaches, and that distinction proved absolutely fatal to Missouri's defense. Sanctuary cities carefully avoided declaring federal immigration law invalid or unconstitutional. Missouri explicitly did declare federal regulations invalid within state borders, which constituted a fundamentally different legal strategy based on what legal scholars call the anti-commandeering doctrine. Liberal sanctuary cities relied on carefully crafted non-cooperation language that avoided challenging federal law's validity. Missouri went much further and declared specific federal gun regulations to be invalid within Missouri's jurisdiction. The Supreme Court viewed this declaration as unconstitutional nullification of federal law, which the Supremacy Clause of the Constitution explicitly prohibits. A single critical word choice in the statutory language changed the entire legal outcome. That drafting mistake cost Missouri the legal defense they believed they had successfully locked in through legislation.
It also puts state laws in jeopardy that are similar to this law, which required people to show proper cause when they apply for permits.
And today, the Supreme Court has answered that question.
On its opening day of the new term, the U.S. Supreme Court rejected Missouri's bid to revive its law aimed at declaring various federal gun restrictions unconstitutional.
Justice Clarence Thomas once again demonstrated exactly why he's viewed by constitutional scholars as a pure originalist interpreter. His dissenting opinion signaled a clear belief that states should possess more inherent power to resist what they perceive as federal intrusion into areas of state sovereignty. Thomas did not defend the specific penalty structure of Missouri's law, but he did defend the fundamental right of states to challenge federal authority through legislation when they believe federal actions violate constitutional limits. Standing completely alone in dissent has never deterred Justice Thomas from articulating his constitutional vision. Thomas has stood solo in dissent more than 70 times throughout his tenure on the Supreme Court. He consistently prioritizes original constitutional text over modern legal frameworks and precedents. His position in this case signals much deeper federalism debates that are coming in future cases. Many constitutional law scholars believe Thomas is thinking decades into the future rather than focusing on immediate political outcomes. Thomas did not lose this constitutional battle in any meaningful sense. He planted a constitutional flag for future litigants and legislators to build from, and reference. This ruling did absolutely nothing to weaken the Supreme Court's landmark Bruen decision from 2022. Bruen remains the most powerful Second Amendment ruling in modern American history. It requires all firearms laws to align with historical tradition of gun regulation. That heightened standard continues to overturn unconstitutional gun restrictions in courts nationwide. Bruen raised the success rate of Second Amendment legal challenges dramatically compared to pre-2022 litigation. Hundreds of gun regulations at federal, state, and local levels have been struck down under the Bruen standard. Courts must now review all gun laws through rigorous historical analysis of founding-era regulations. The rights of lawful gun carriers and owners have expanded significantly since the Bruen decision was issued in 2022. While Missouri lost this particular strategic approach, Bruen continues driving significant victories for gun rights in courtrooms across America every single month. Missouri acted as aggressively as it did because gun owners nationwide have witnessed what they view as unprecedented federal enforcement actions, expanded compliance inspections, controversial reclassification of firearms parts and accessories, and systematic enforcement sweeps have escalated concerns among Second Amendment advocates. This widespread concern fueled state lawmakers to attempt building a legal wall against federal enforcement. The sense of urgency was genuine and based on real regulatory actions, even if the legal execution of the response ultimately faltered under constitutional scrutiny. Federal firearm dealer inspections increased significantly in frequency during recent years. Controversial reclassification of items like bump stocks and certain frames triggered massive legal and political controversy. Millions of firearms transaction records have been digitized and maintained in federal databases. States legitimately fear regulatory administrative action being used as a substitute for actual legislation. Missouri saw what they interpreted as warning signs and acted aggressively. The Supreme Court reminded them that constitutional structure draws the legal lines, not emotion or political urgency. The Constitution's Supremacy Clause explicitly ensures that valid federal law outranks conflicting state law in areas of federal authority. Missouri attempted to bypass this fundamental principle by arguing their law was simply about non-enforcement rather than invalidation, but one critical word in the statutory language shifted the law from permissible non-cooperation into prohibited nullification. That single distinction was sufficient to invalidate the entire statute under constitutional analysis. The anti-commandeering doctrine clearly allows states to refuse to enforce federal law using state resources. Constitutional nullification, which attempts to invalidate federal law within a state's borders, is explicitly prohibited. Missouri crossed that bright constitutional line with specific statutory language choices. The court reaffirmed Supremacy Clause limitations in no uncertain terms. Had the statutory wording focused solely on refusing cooperation without declaring federal law invalid, the legal outcome could potentially have been dramatically different. Red states with Republican-controlled legislatures are already systematically revising their gun rights laws based on this Supreme Court ruling. They will carefully avoid using the word invalid or similar nullification language, and instead emphasize structured refusal to assist federal enforcement. New laws will rely entirely on the well-established anti-commandeering doctrine and the heightened standards from Bruen. Legal experts expect a significant wave of rewritten state measures specifically designed to withstand constitutional scrutiny in federal court. States are removing any nullification language from proposed legislation. Focus is shifting to carefully structured non-cooperation clauses. State legislatures are coordinating directly with specialized constitutional attorneys. The next generation of Second Amendment protection bills is already being drafted in multiple state capitals. This Supreme Court decision was not the end of state resistance to federal gun control. It provided the precise blueprint for what must happen next. Missouri's legal defeat actually delivered critical clarity rather than permanent defeat for the broader movement. The Supreme Court signaled exactly where constitutional limits exist and, perhaps more importantly, where significant opportunities remain for effective state legislation. Gun rights protections remain constitutionally strong, and history-based judicial review still governs how regulations get evaluated. The next wave of Second Amendment state statutes will be smarter, more carefully drafted, and more constitutionally resilient. That's it for today, folks. See you in the next video.